What is really occurring in federal and state courtrooms, a legal examination of jurisdiction, consent, and contractual coercion. 1. Distinction between penal and criminal jurisdiction. The distinction between penal and criminal law is often obscured in the public mind, yet the divergence has substantial legal implications. Penal codes generally govern administrative offenses, including regulatory violations such as traffic infractions. Unlike criminal offenses, penal sanctions do not always require proof of mens rea and frequently originate from statutory or contractual presumptions. For instance, a traffic citation, issued ostensibly as a criminal matter, is in reality processed through an administrative mechanism that lacks traditional adversarial safeguards. 2. Champerty and commercialized law enforcement. The solicitation of penal fines by law enforcement may amount to a modern form of champerty, an archaic but still instructive legal concept that once rendered it unlawful to initiate legal proceedings for pecuniary gain without a direct stake in the matter. When police officers, functioning as agents of municipal corporations, initiate enforcement actions at the behest of prosecutors for administrative gain, the interaction arguably constitutes an economic enterprise under the guise of law enforcement. The constitutional implications of such conduct merit closer scrutiny. 3. Presumptions of jurisdiction and maritime enforcement mechanisms. Traffic enforcement actions are often predicated upon contractual presumptions. A key legal fiction is that the state driver license binds the individual to a maritime jurisdiction. This interpretation stems from the notion that state-issued licenses represent commercial privileges granted by the state, thereby implying consent to administrative regulation. Similarly, the legal classification of a vehicle as a motor vehicle under federal and state codes suggests commercial activity, enabling the state to assert a financial interest in both the conveyance and its operator. 4. Contracts compelled under duress, the citation paradigm. When an individual signs a traffic citation under threat of arrest, the encounter functions as a contractual arrangement. The citation becomes a promissory instrument to appear in court, a compelled contract between the alleged offender and the state. However, the presence of coercion or duress raises serious legal concerns. According to established contract law principles and codified statutes such as Texas Business and Commerce Code Section 3.408, aligned with the Uniform Commercial Code, contracts lacking voluntary assent or adequate consideration may be void or voidable. 5. Consideration and antecedent obligation. Valid contracts require an exchange of value, termed consideration, to be enforceable. In the context of a traffic citation, the absence of consideration from the state actor invalidates the contract, unless there exists an antecedent legal obligation. The citation operates on the presumption of such a pre-existing duty, but this assumption is rarely substantiated with evidence. The resulting legal fiction undermines the individual's capacity to raise meaningful defenses in administrative proceedings. 6. Unconscionability and public policy violations. The doctrine of unconscionability further challenges the legitimacy of contracts executed under coercive circumstances. Defined as terms so one-sided as to offend public conscience, unconscionable contracts may be voided by courts. When individuals are coerced into legal obligations under threat of imprisonment, with no opportunity to negotiate, decline, or comprehend their rights, such practices arguably violate both contractual norms and constitutional protections.